Today I'm going to be talking to you about settlement agreements. You may have come across settlement agreements before, or as they were known formerly, compromise agreements. This may have been from the perspective of an employer or an employee. If you have, you're likely to understand how these agreements can be used in a positive way, usually to draw a line under an employment relationship and allow both parties to go their separate ways amicably on agreed terms and with limited conflict. Settlement agreements can also be used to settle claims whilst an employee remains in employment, but obviously that's a bit more unusual. The intention of a settlement agreement is that by signing, an employee is agreeing to waive their rights that they may have against their employer in connection with or arising out of their employment or its termination. In return for waiving their rights, the employee will receive an agreed exit package. We deal with settlement agreements on a daily basis for both employers and employees. For employers, settlement agreements are usually offered when there's a possibility that they may be at risk of an employee bringing a claim against them. This may be due to actions or circumstances which have already happened, or an agreement may be offered in order to avoid action being taken, which may result in the employee having grounds for a potential claim. A few examples for you. An employee raises a grievance. In that grievance, they inform you that they believe their line manager has been treating them differently because they're of an ethnic minority. Dealt with properly and following the correct grievance procedure, it may be possible to resolve the issue, take any appropriate action, and the employee may be happy to continue working for you. But what if the employee expresses that they don't believe they can continue working for you as the employment relationship has already broken down? There's a potential risk that this employee could resign, bring a claim for constructive dismissal, along with discrimination on the grounds of race. When investigated further, you should have better knowledge of the treatment they've allegedly been subject to, and may be able to assess the risk of a potential claim. It may be relevant to offer a settlement agreement after the investigations have taken place. Having said that, investigations take time and resources. What if this could be avoided? It may be possible to have a without prejudice conversation with the employee to discuss a potential settlement at an early stage. What about the employee who's been on long-term sick leave, or who's had a number of sickness absences, especially if they are for the same or a related illness? I'm sure most employers in the room have come across this at some point before. If the employee is able to satisfy the definition in the Equality Act, this employee could have disability. Taking action in respect of that employee's sickness absence, which is in connection with the potential disability, could be discriminatory. There's also the obligation to consider whether any reasonable adjustments should be made in order to assist the employee in returning to work. You may wish to consider offering that employee a settlement agreement so that if agreed, the employee can't bring a claim against you, but the employment relationship is terminated. Then there's the other side of the equation. What if you're an employee who's, say, in your 60s, you have no plans to retire, but your manager keeps commenting on your performance and referencing your age, and you believe they're trying to push you out of business? You may have grounds for a claim for age discrimination and potentially constructive dismissal. But you know these claims are difficult to prove, will cost money to be legally represented. You're also aware that in order to give your claim the best opportunity of success, you should first raise a formal grievance in order to try and resolve matters using internal procedures. You may consider asking your employer for a protected conversation with a view to negotiating a settlement to leave the business on agreed terms, without undergoing a lengthy grievance procedure or the risk and effort of litigation. So if a settlement agreement's on the cards, what could you expect an exit package to be made up of? This will vary on a case-by-case basis, and for many employees, the most important part of a settlement will be the payments they receive. An agreement could contain a payment in lieu of notice, accrued but unused holiday pay, a bonus, redundancy pay. Usually there's an incentive payment for an employee to sign the agreement which is above their contractual entitlements. This is termed a compensatory or ex gratia termination. The settlement may also deal with other items such as benefits including healthcare, company car or car allowance, pension payments, shares, garden leave, an agreed reference, or the wording of an announcement to other staff. A settlement agreement can also reinforce duties of confidentiality and existing restrictive covenants by referring to those which are contained in the employee's contract of employment. In circumstances where restrictive covenants are not currently in place but are required going forwards, they can also be introduced as part of a settlement agreement. If after signing the settlement agreement the employee breaches these restrictions, as long as the terms of the restriction itself are potentially enforceable, an employer would be able to demonstrate that the employee had knowledge and agreed to the restrictions being in place upon termination. So they stand a better chance of enforcing the restrictions should they be required to do so. Depending on the wording of the settlement agreement, it may be possible to recoup any compensatory payment in addition to reasonable legal fees if an employee breaches a duty of confidentiality or restrictive covenants as a breach of contract claim. In order for a settlement agreement to be legally binding, it must be in writing, it must relate to a particular complaint or particular proceedings, it must state that the legal conditions regulating settlement agreements have been satisfied, and the employee must have received legal advice on the terms and effects of the proposed agreement. The advisor must have insurance in place to cover the risk of the claim in respect of their advice, and they must be specifically named in the agreement. It's important that if you are considering offering an employee a settlement agreement, you obtain legal advice. Of course, if you're a pet client, please give us a call. Not only can we assist you in ensuring that any settlement agreement is legally compliant, but we can also give guidance on settlement negotiations and how to approach the topic of settlement agreement in a way in which the discussions are off the record, meaning that they cannot be relied upon later if the employee decides not to sign the agreement and pursue a claim against you. A tool used in many settlement negotiations is the ability for the first £30,000 of any compensatory payment to be made free of tax and national insurance contributions. It used to be the case that if an employer made a payment in lieu of notice, but their contract didn't contain a payment in lieu of notice clause, then this would technically be a breach of contract and as a result would be classed as a compensatory payment and could count towards the £30,000 tax-free. From the 6th of April 2018, HMRC have clamped down on this and all payments in lieu of notice must be subject to tax and national insurance deductions in the usual way. A further change which is due to come into force from the 6th of April next year is that any part of a termination payment which exceeds £30,000 will also be subject to employers' Class 1A national insurance contributions. A potential issue with settlement agreements for employers is that, as we've already mentioned, in order for it to be signed off, the employee is required to obtain legal advice as to the terms and the effect of the agreement. As signing the agreement will mean that the employee is waiving their rights to bring their potential claims, the advisor should explore the reasons why the employee is being offered the settlement agreement and determine whether they believe the terms reflect a fair and appropriate settlement of their potential claims. Of course, an employer's position is that they're trying to pay the employee as little as possible, and an employee wants to receive as much as possible. The position's very much dependent on a case-by-case basis, but sometimes an employee won't necessarily know what claims they may be able to bring in an employment tribunal. By offering a settlement agreement which requires an employee to receive independent advice as to their potential claims, could you as an employer be walking into a potential trap? There's the potential to avoid this by starting the claim process as an employer. In order to bring a claim in an employment tribunal, you must first go through the ACAS early conciliation process. If you start this as an employer, the employee's claims could potentially be settled by way of a Cot 3 agreement, which has the same effect legally in relation to claims that can be brought in the employment tribunal. To sign off a Cot 3 agreement, it's not a requirement for the employee to see an independent advisor, and ACAS can only give guidance on potential claims. They can't actually give advice to an employee. This is an option which is worth a thought in the right circumstances, although note that a Cot 3 agreement cannot settle claims which may be brought in a civil court, only in employment tribunal. Finally, I wanted to leave you with a real-life success story. An employee approached us, having had their employment terminated out of the blue with immediate effect. In the same meeting, their employer gave them a settlement agreement offering payment in lieu of notice, £50,000 in payment of their shares in the business, and a consultancy agreement to carry on working for the company on a self-employed basis. The employer argued that the employee's shares were worth very little as they were a bad leaver as they'd been dismissed. With the benefit of our advice and a proper valuation of the shares, the employee brought a claim against the employer instead of accepting the settlement agreement on offer. This claim settled for just over £250,000. This just shows how important legal advice can be and why settlement agreements can't be signed off without it.